96 gigabytes, 14,000 pages. And that is just the first round. When the federal government decides they are coming for you, they do not show up with a folder. They back up a semi-truck to your lawyer's office and unload everything they have been building for months. Every text message, every phone call, every search warrant, every video from every camera at every location they raided. That is exactly what just happened to Pooh Shiesty's legal team. And the worst part? They said more is coming. If you thought this case was going to get quietly resolved in a few months, you need to sit down, because what just got filed in the Northern District of Texas tells a completely different story. 5 federal charges, 10 defendants, a judge who already granted the complexity motion, and a lawyer who just walked into a room expecting to meet a street rapper and walked out genuinely impressed. This situation is bigger than most people are treating it. Let's break down exactly what is happening and what it actually means.
Boy, when I tell you Pooh Shiesty's team was about to walk into an avalanche, listen to this shit. Breaking news.
For people who are just catching up, Pooh Shiesty's government name is Lantrell Williams Jr. He is one of the most commercially successful rappers to come out of Memphis in the last decade. His 2021 debut project went platinum. His feature on Big 30's Back in Blood became one of the most streamed rap songs of that year. He had every look of being the next major voice out of the South. Then he caught a case, and then another one. And now he is sitting in the middle of a federal indictment in the Northern District of Texas that is about as serious as it gets short of a murder charge. The indictment was filed on the 28th of April, 2026. His lawyer was retained in early May 2026. And on May 19th, just weeks after getting retained, that lawyer's team received the first production of discovery material. 96 gigabytes, 14,000 pages, just the first batch. The government has already told the defense to expect at least 2 more discovery productions after this one, which means the 96 gigs and 14,000 pages that just landed on their desk is only the beginning of what the prosecution has built. Now let's talk about what he is actually charged with, because this is where it gets serious in a way that goes beyond anything he has dealt with before.
District Judge for the Northern District of Texas, Dallas Division. 1. The defendant, Lantrell Williams Jr., along with 9 additional defendants, is charged in a 5-count indictment involving allegations which include conspiracy to commit kidnapping, aiding and abetting kidnapping, conspiracy to commit extortion by force, violence, and fear. Aiding and abetting extortion by force, violence and fear, and aiding and abetting interstate transport of stolen goods. The offenses are alleged to have
5 counts. Let's go through each one because they are not all equal, and understanding the difference matters. Count 1 is conspiracy to commit kidnapping. This is a federal charge that carries massive sentencing exposure. Under federal law, kidnapping convictions can result in decades in prison. The conspiracy charge means the government does not need to prove he personally grabbed someone. They need to prove he was part of an agreement to do it, and that at least one person took a step toward making it happen. Conspiracy charges are notoriously difficult to defend because the bar for what counts as participation is much lower than most people think. Count 2 is aiding and abetting kidnapping. This is the direct participation charge that sits alongside the conspiracy charge. Aiding and abetting means you helped, facilitated, or encouraged the kidnapping even if you were not the one who carried it out. The government is essentially covering both angles: conspiracy for the planning side and aiding and abetting for the execution side. Count 3 is conspiracy to commit extortion by force, violence, and fear. This is a specific type of extortion charge under the Hobbs Act, which is one of the most commonly used federal statutes in organized crime and gang prosecutions. Force, violence, and fear means they are alleging this was not a subtle scheme. They are saying people were physically threatened or harmed to get what the defendants wanted. Count 4 mirrors Count 3 the same way. Count 2 mirrors Count 1. Aiding and abetting extortion by force, violence, and fear. Same logic. Cover the planning side with conspiracy. Cover the execution side with aiding and abetting. Count 5 is aiding and abetting interstate transport of stolen goods. This charge is important for a specific legal reason. The moment you cross state lines with stolen property, the federal government has jurisdiction. Local prosecutors cannot touch federal jurisdiction cases. This is the charge that makes it impossible to argue this was a state-level matter. Together, these 5 charges create a picture of what the government is alleging. They are saying there was a plan, people carried out the plan, someone was taken against their will, threats and force were used, and stolen property ended up crossing state lines. That is a complete criminal narrative from planning to execution to evidence. And they have 96 gigabytes of material they believe supports all of it.
In early May 2026, on May 19th, 2026, counsel recovered over 96 gigabytes of discovery, approximately 14,000 pages in the first production, and anticipates receiving 2 additional discovery productions in the near future. Counsel anticipates receiving voluminous reports from multiple law enforcement agencies, as well as search warrants with associated documents. Counsel has requested and should be receiving all audio and video evidence from the execution of multiple search warrants and searches of property associated with defendant that is central to the government's claims against the defendant. After all of the...
Most people hear 96 gigabytes and picture a hard drive. But in the context of a federal case, that number means something very specific and very concerning for the defense. 96 gigabytes of discovery in a criminal case means the government has been watching, recording, and collecting for a long time. It means there are phone records. It means there are surveillance videos. It means there are text message logs. It means there are financial records. It means there are recordings from wiretaps or consensually monitored conversations. It means there are photos taken during law enforcement operations. It means there are witness statements written up by agents and turned into formal reports. It means there are warrants, search warrants, arrest warrants, wire warrants, each one accompanied by an affidavit explaining why a judge signed off on it. The podcast host put it the way most people who have watched federal cases play out would put it.
14,000 pages? Bruh. Yeah, y'all better have a team. Y'all better split that shit up.
That reaction is the right one, because this is not a case where you have a few surveillance clips and a witness who says they saw something. This is a case where the government has built a document mountain, and the defense has to climb every inch of that mountain before they can even think about trial strategy. There is also a specific detail in the discovery motion that deserves attention. The defense specifically requested all audio and video evidence from the execution of multiple search warrants. Multiple. Not one search warrant. Multiple locations were raided. Multiple properties were searched. Multiple pieces of physical evidence were collected. Each one of those search warrants comes with its own paperwork trail. The warrant itself. The affidavit that justified the warrant. The inventory of what was taken. The chain of custody documentation for every item seized. Reports from every agent who was present at the execution. Photographs of the location before, during, and after the search. Multiply that by however many warrants were executed, and you start to understand why 14,000 pages is just the first batch. The host's comparison was accurate. The feds do not bring a briefcase. They back up the dump truck.
With counsel who don't know shit about nothing. The feds do this all the time. They dump mountains and boatloads and back up the goddamn dump truck and back up a semi. Bruh, they come with it all. So the fact that they have 96 gigs and 14,000 mother flipping pages to read through, that...
Here is something that most people covering this case have glossed over, but is actually one of the most significant developments so far. The defense filed what is called a motion to certify the case as complex under the Speedy Trial Act. The Speedy Trial Act is a federal law that sets time limits on how long the government can take to bring a defendant to trial. Under normal circumstances, a federal defendant has to be brought to trial within 70 days of indictment or arraignment, whichever comes later. The act exists to protect people from sitting in legal limbo while the government takes its time preparing. But there is an exception. If a case is certified as complex, the time limits of the Speedy Trial Act get suspended, or in legal terms, tolled. The clock stops, and a new scheduling order gets issued by the judge that gives both sides the time they actually need to prepare. The motion Pooh Shiesty's team filed made a straightforward argument. 96 gigabytes of discovery, 14,000 pages just in the first production. More coming. Multiple law enforcement agencies involved. Witnesses in multiple locations. This is not a case that can be responsibly prepared for trial in 70 days. The defense cannot do its job properly in that time frame, and the prosecution knows it. What made this motion particularly significant is the word that appeared right at the beginning of the filing: unopposed. The government agreed. Both sides signed off on the complexity designation, which means this was not a contested motion where the judge had to weigh arguments from both sides. Both the prosecution and all defendants acknowledged that this case requires more time than the standard rules allow, and the judge granted it immediately.
This is Dallas Division, United States of America versus Lontrell Williams Jr. Order. On this day, the court considered defendant's unopposed motion to certify case as complex pursuant to Title 18 United States Code Section 3161H7B2, which constitutes excludable times under the Speedy Trial Act. After considering defendant's motion, the motion is hereby granted. Accordingly, it is so ordered that the above styled and numbered cause is certified as a complex case pursuant to Section 3161H7B2 of Title 18 United States Code, a new schedule.
Now let's talk about the legal team situation, because this part of the story is something people need to understand going forward. There was a lawyer named Bradford Cohen who was originally involved in this case. Bradford Cohen is a well-known criminal defense attorney who has represented a number of high-profile rap artists over the years. He had a history with this type of case and this type of client. But something happened in that room. A disagreement. A difference of opinion about strategy and direction that apparently got heated enough that the legal team fractured. Bradford Cohen is no longer on the case. He was not just quietly replaced according to what the host laid out. There was an actual argument about the direction the defense should take. And when it became clear the two approaches could not coexist, the team split. Pooh Shiesty chose Dan Cogdale. And Dan Cogdale went on camera to talk about what he found when he walked into that room to meet his new client. His description was not what anyone expected.
I'll let y'all figure it out.
First met Lontrell Williams Jr., aka Pooh Shiesty. I was expecting straight up, thug life, no common sense, arrogance beyond. I mean, that's just, you listen to that music and that's that's the person you've got built in your head. He's a funny kid. He's smart. He's witty. He wasn't unreasonable at all. He was appreciative. I mean, I walked away thinking, I really like him, which liking your client is not a necessary part of your job description here. And frankly, an important part of your job description, whether it's a rapper or a CEO, is saving our clients from themselves. They have generally made at least a bad decision before we got there, but I really enjoyed him, and I'm looking forward to working with him. But he's a far different young man than I expected.
That statement from a lawyer who walked into a federal meeting with a full team of 5 attorneys expecting one thing and got something completely different is worth taking seriously. Defense attorneys are professionals at reading people. They meet clients in the worst possible circumstances: scared, angry, defensive, desperate, or sometimes completely shut down. A lawyer who says they walked away genuinely liking a client they expected not to like is telling you something real about what happened in that room. And the part where Cogdale says liking your client is not a necessary part of the job description, that is a lawyer's way of saying this is not routine praise. He is not performing. He is making the point that his personal feelings are irrelevant to doing the job, and then telling you that in this specific case his personal feelings surprised him. He followed that up with something that went beyond professional courtesy.
Expected.
When you come away like after you met Pooh Shiesty and you realize what a decent kid he really is, it makes you work that extra hour at the end of the day. You want to do a good job for all your clients. This kid is so gracious. He's appreciative. Couldn't have been more respectful. We went in with a team of 5 lawyers,
right.
And everybody walked away out of that.
The Bradford Cohen situation is worth examining because it says something important about how this case is being approached strategically. When a legal team fractures mid-case over direction, it usually means one of two things. Either the lawyers have genuinely different philosophies about how to handle the evidence in the charges, or the client has made a decision about the kind of fight they want to put up, and not everyone on the team agrees with that decision. The host's description of what happened makes it sound like both things were true simultaneously. Bradford had his way. Dan had his way. They laid both approaches on the table. Pooh Shiesty listened to both arguments, and he picked Dan Cogdale. As a client, he did not owe anyone an explanation for that choice. Clients can dismiss attorneys without giving reasons. Lawyers are ethically required to explain their withdrawal to the court, but the client does not have to justify who they choose to retain, which is exactly what happened. The question that matters now is what direction Dan Cogdale's approach represents. Is this a team that is preparing to fight every single charge at trial? Or is this a team that is building toward a negotiated resolution?
They disagreed with a whole lot in that room, and Pooh Shiesty chose up over Bradford Cohen and chose Dan. That's how that happened. There was a whole entire argument that went on about direction. Bradford had his way, Dan had his way, and they just broke it apart and split, and Pooh Shiesty ultimately went with that lawyer. And that's why when Bradford Cohen asked to be released, Pooh Shiesty don't have to give.
This is the question that everyone who has been following this case wants answered. Is Pooh Shiesty going to take a plea deal, or is he going to trial? The honest answer, based on everything that has been filed and everything that has been said publicly, is that the numbers do not favor trial. Here is how federal cases actually work for most defendants. Approximately 90% of federal criminal cases end in guilty pleas rather than trials. That number is not an accident. Federal prosecutors have a conviction rate at trial that hovers around 90%, which means if you go to trial against the federal government, you lose most of the time. The discovery that was just dumped on Pooh Shiesty's team, 96 gigabytes, 14,000 pages, audio and video from multiple search warrant executions, reports from multiple law enforcement agencies, represents months or years of investigation. The government does not indict people they do not believe they can convict. The complexity motion that just got granted also tells you something about where this is headed. Both sides agreeing that this case needs more time is not the posture of a defense team that is preparing a quick knockout punch at trial. It is the posture of a team that needs time to review everything the government has, understand exactly how strong that evidence is, and then make a realistic assessment of what a negotiated resolution might look like. The host was direct about his read on the situation.
Indigent or whatever the hell and anything. And that wasn't the case. So shout out to Pooh Shiesty. We gonna see what happens. Just because y'all hear all that shit, it is what it is. Me personally, I'm fully expecting plea deals, and that's gonna be that. And I'm expecting a plea deal for All-Star JR. If y'all want a video on that, let me know, and that'll be the first thing we drop tomorrow, because Lord, there's some shit that just happened. And I hate to say it, that boy overly cooked like fried rice. But what do y'all think on this one? Is y'all thinking like me, like Pooh Shiesty gonna end up signing a plea agreement and that's gonna be that? Or do y'all think it's gonna go ahead and take this shit to mother effing trial?
There is one more layer to this story that connects it to a conversation that has been happening in hip-hop for the past several months. And it involves Gucci Mane. Gucci Mane's reputation took a significant hit recently because of his handling of the Pooh Shiesty situation on the music side. He made a song. He talked about details. He filed paperwork. The streets had opinions. His credibility with a certain generation of hip-hop listeners took damage. But here is the thing the host pointed out that is both uncomfortable and accurate. If Pooh Shiesty ends up taking a plea deal, which the evidence volume strongly suggests is the likely outcome, then Gucci Mane's position actually looks better in retrospect. Because Gucci's argument, stripped of everything else around it, was that he cooperated with the system to protect his own interests, and he did not take the stand against anyone. If Shiesty takes a plea deal, the conversation shifts. It is no longer purely about Gucci's choices in isolation. It becomes a comparison. And that comparison is going to be uncomfortable for some people who were very loud about their opinions on Gucci earlier this year. The host put it plainly and without sugarcoating it.
unfortunately, it's going to help out Gucci Mane's image because Gucci Mane going to say, I did what I did, but I ain't take the stand.
Here is where things stand right now. Pooh Shiesty is facing 5 federal charges: conspiracy to commit kidnapping, aiding and abetting kidnapping, conspiracy to commit extortion by force, aiding and abetting extortion by force, and aiding and abetting interstate transport of stolen goods. 9 other defendants are charged alongside him. His legal team just received 96 gigabytes and 14,000 pages of discovery in the first production alone. More is coming. Multiple law enforcement agencies are involved. Audio and video from multiple search warrant executions is being turned over. The case has been certified as complex by a federal judge. The Speedy Trial Act clock has been stopped. A new scheduling order is coming. This case is not resolving quickly. His new lawyer, Dan Cogdale, walked into a meeting expecting one thing and found something completely different. And he said publicly that the person he met made him want to work harder. The Bradford-Cohen split signals that there was a real disagreement about strategy. The direction Cogdale represents is not yet fully clear. And the question every person who has been following this case is asking, plea deal or trial, does not have a public answer yet. But 96 gigabytes of federal evidence and a 5-count indictment that covers both the planning and execution of the alleged crimes tells you something about the kind of fight that is ahead. Pooh Shiesty is talented. His music is real. His lawyer seems to genuinely respect him as a person. But the federal government does not indict people they do not believe they can convict. Drop a comment and let us know whether you think this ends in a plea deal or goes to trial. And subscribe so you catch the next update on this case when it drops.